What can be patented? Patents can be granted only for an invention that pertains to a field of technology. Inventions under the Act can be granted for a new product or a process. The invention should involve an inventive step, and it should also be capable of industrial application. Now, this is the definition of invention which is mentioned in section 2(1)(j) of the Patents Act. What is important here is that invention has three requirements: novelty, inventive step, and utility. But for something to be an invention and for something to be captured as a patent, the product or the invention should manifest itself in the form of a product or a process. So that is why you have the new product or a process mentioned together. So if the invention cannot be envisaged as a product or a process, then a patent cannot be granted. Invention can also cover improvements to existing inventions. So you have inventions which are new, involve an inventive step, and are capable of commercial industrial application. The same yardstick can also be applied to improvements to existing inventions, provided those improvements are new, they involve an inventive step, and they are capable of industrial application. Novelty or newness of an invention. The Act does not define novelty per se. There is no definition of a novelty, but the Act does gives you instances on how you can understand a new invention. Definition of new invention under the Act, under section 2(1)(l), new invention means any invention or technology. Now, the definition is important, is the fact that though novelty or the fact that newness is not defined under the Act, there is a definition of new invention under the Act. So we understand this definition, new invention, as defining the new part in section 2(1)(j). So this new is defined by this phrase, new invention, and this we understand because what is contained in this definition is the requirement of novelty. The second element of patentability, that an invention should involve an inventive step. Inventive step has been defined in section 2(1)(j)(a). The earlier definition was much simpler definition. It just said inventive step means something that is not obvious to a person skilled in the art. But now the inventive step definition has been amended to include two other components. The third requirement for determining patentability is that the invention should be capable of industrial application. Capable of industrial application is defined under 2(1)(ac). It states that in relation to an invention means that the invention is capable of being made or used in an industry. So if it is capable of being made or used in an industry, it is understood that it is capable of industrial application.